Nicole Davidson, welcome to the Resolution Room.
It's an absolute pleasure to be here, Damien.
Excellent. Now, I'm going to have a crack at your background, but please, at the end, correct me. So you're an accredited mediator, and I've really enjoyed reaching out across the aisle to other mediators in the community, principally a commercial mediator. You're recognised in Doyle's in 2025. You've won an ADR award. Before all that, you've got a Bachelor of Law and a Commerce degree as well. You're an insolvency practitioner and you've worked in investment banking as well, and more recently as a mediator. Now, I know that's a really brief snapshot of your career to date, but have I done it some justice, Nicole?
Yep, you absolutely have. You've nailed most of that. And I guess the one thing that I'd say that is probably a really important thing for the way that I work is that I actually spent a number of years as well in the learning and development space, looking at much more around the soft skills piece. So there's that sort of mix of the commercial, the legal, the soft skills that all feed into what I was doing. So very long, windy career that I thought was all a bit flaky at the time feeds beautifully into what I'm doing now.
Great stuff. Well, we're going to touch on those inverted commas soft skills and how they work with lawyers in particular. But before I do that, how did you come into your mediation practice?
I think there's so many routes into mediation. Nobody really grows up going, I'm going to be a mediator. The way that I came into it was that I had started working for a training consultancy that delivered training around negotiation, influence, difficult conversations, all grounded out of Harvard theories. And I absolutely loved this material. And I really sat down thinking, gosh, if only somebody had taught me this stuff much, much earlier in my career. But after a couple of years of training that material, I thought it's great being able to work with people and give them these skills, but I'd much rather be putting these skills into practice as well, so that when I'm training, I'm actually being much more authentic, because they're things that I'm consciously using in a business context on a regular basis as well. And so mediation stood out to me as the ultimate way to help people with negotiations.
Oh, that's fantastic. And it's interesting that I'm doing the flip side. I come at it from legal work, mediation, and now I'm looking at the leadership and training space. So I come at it from a different order, if I could call it that. Your practice is principally in commercial mediation?
Yeah, and very much I sort of play to my background, being able to go through financial statements and understand them, understand commercial drivers of businesses, to really dig into the interests that parties have at dispute time. I very much focus on that as my area. And look, I know that we're always told that once you're a mediator, you can mediate anything. I really believe it's the quality of the questions that the mediator asks that makes the difference between a good mediator and a great mediator. And if you've got more subject matter expertise, I believe you can ask the parties more incisive questions. So that's where I've made a conscious decision to sort of stick in my lane and really focus on that commercial side.
I think you're right. I mean, I've been in 30-year insurance lawyer, and it's not so much that I'm in my comfort zone, but that sort of embedded expertise does just bring credibility to the table, I suppose. So I understand what you're saying. My mediation work is broader than that, but that seems to be the mainstay of my work, and I'm happy with that. I see from your email as Nicole Davidson Negotiation, so you're very much a negotiation trainer. Talk me through, if you don't mind, the negotiation training aspect of your business. That comes out of your leadership training background, huh?
Yeah, well, look, as I said, I mean, I was working for a consultancy that focused purely on this, and I really believe that mediation, not so much mediation, but negotiation is a skill that everybody should be taught, because it's not something that necessarily comes naturally, and we get very flawed views of what negotiation is from Hollywood dramas and things like that. So I've been teaching negotiation now for, it must be over 15 years now. And what I do is I work with people running really experiential programs most of the time. So when I learnt how to teach negotiation, it was with an organisation set up in part with the assistance of Roger Fisher, who is the author of Getting to Yes, leading very famous negotiation text. And the way that we taught there is very much the way that negotiation is taught at Harvard. The methodology that I now use is very much aligned with that. Really practical, experiential, and trying to get people that hands-on experience. Really trying to just raise their awareness of what they're already doing, because most of us, particularly lawyers, a lot of them are very good negotiators, but they don't have a system that they wrap around. So when they get to something that's a little unusual, maybe they're not as good as they are at their day-to-day negotiations.
I did the Harvard Mediation Intensive, which is part of the same school, but I know there's a program on negotiation as well. So I teach a little bit on negotiation more to get in front of lawyers and build my mediation practice. But let me say this to you, Nicole. I'm a lawyer. I think the strength of my case is about the facts and the law. Why isn't that enough? What else do I need to know about negotiation to be effective?
The interesting thing is, and this is what I found over the years, is when I first started learning negotiation, it was pretty simple. It's like Harvard's 7 elements. What are the interests? What are the options? What are the standards? All of this. There is obviously content expertise that somebody needs to have to be a good negotiator. You need to understand the law. You need to understand the facts. When we think about resolving disputes using the law, if I think about the Harvard 7 elements, and without going into all of those, the law is very much based around standards. It's a right and a wrong. It's very black and white. When we are trying to settle something before trial, or if we're going through a mediation, what we can look at is interests. And that says, well, without even thinking about who's right or wrong, let's just figure out what everybody cares about, what's important to them, and can we work out a practical solution that both parties get their interests met to a certain extent, regardless of whether the law is on their side or not. So there's firstly that. It's a different approach to problem solving. But the other thing is my expertise over the years has been much more around psychology and understanding people and the dynamics and the psychology of conflict. And that's something that most lawyers are never taught.
That's right. So begs the question, what are the common mistakes that you think lawyers make in the negotiation context? What do you see?
There is a focus too much on the legal side of things. And, once again, the legal case and the strength of the legal case is important. But we also know that generally both parties go into a case thinking they've got reasonable prospects of success, and one of them will be proved wrong. So I think that's the first mistake, is to rely solely on that. The other mistake that I see is taking the emotion, talking about the idea of taking the emotion out. Let's just put the emotion aside. And the reason I say that's a mistake is because we are dealing with humans. Look, it does depend on the dispute. I do a lot with the small business space. It might be a corporate on one side, but a small business on the other side. And you absolutely need to recognise the person, where they're coming from, what their emotional and sort of psychological needs are, because if they don't have some of those met, they will resist the actual practical solutions a lot more. If you can actually deal with them in a way where they feel like they've been respected, or they feel like there's a degree of fairness, there's a whole bunch of things that we're looking for, then they're much more likely to be able to move to the practical solution as well.
Yeah, so there's this innate need to be seen and heard that is always surfacing and in every conflict. And I guess why Fisher and Urey was such a game changer and seminal in our understanding was looking at what are the interests, what are the underlying needs, or what is maybe not being expressed necessarily through the legal framework, but really is driving decision-making and getting people to really drill down and understand that. And that's effectively a core part of your negotiation teaching, understanding that framework.
Yeah, absolutely. And, one of the things that I'm constantly looking at is, when these disputes come before me, often the problem itself is not very complex, but the reason it's escalated is because how the communication has proceeded along the way. Somebody feels like they weren't given a chance to be heard. They feel like they've been dismissed. There's been some form of miscommunication on both sides often. It's not about what's gone on. If it had been handled differently, it would never have got to the point where lawyers needed to come in and it just would have been dealt with in a much, much easier way.
I see. Do you think that in terms of lawyers, and you have been one, that there's an increasing understanding of the need for negotiation training? Are you met with any resistance, or are you find lawyers are more open to training in that space?
I think that's a really interesting question. I think the first thing I'll say is when I was a lawyer, I was never a disputes lawyer. So there's quite a difference there to start with, I think. But I think what's really interesting is I think among junior lawyers, there is an appetite for this sort of training, and they're all quite keen to develop the skills. I spent a number of years working at the College of Law as an adjunct lecturer there and teaching negotiation, and people loved it. You know, the students coming through all found it really interesting. They loved this idea of negotiating disputes and mediating as a way of getting things resolved. But I think what happens as they go through is there's a couple of things, and I find with senior lawyers, often they don't think they need negotiation training because they're already successful and they're doing well, and they don't necessarily think they need to add to their toolkit. So I think that's an interesting challenge. And I think the idea of being in a room full of their peers and seeing that there are things that they could be doing better is quite confronting. So I think there's a bit of a resistance at senior levels to actually stepping up and finding that this would be a useful way to spend their time, particularly when you take into account the billable hour and all of that. But what's fascinating is that, you know, on occasions I do get more senior lawyers in the room, or I might bring a partner from a firm in to actually also give feedback when I'm running training. So it's sort of I'm doing it from this theoretical perspective, but then they've got a partner from the firm who's putting their own spin on it. And the number of times that they come out and they say, wow, that was amazing, I actually really learned something from that, is quite fascinating to see because you know, this is this whole idea that we develop this skill of negotiation very subconsciously most of the time. It's trial and error. It's what we've seen other people do that we like or we dislike, or it's what we've tried that worked or didn't, but there's no real overarching system or strategy to it. And that's what I bring to people. I give them a framework to put all of their negotiations in so that they've got a common language regardless of whether it's a dispute negotiation or a front-end negotiation or a negotiation with a peer about resourcing. They all sort of follow this same underlying structure.
I want to come to that structure, but I just wanted to touch on something before we do, which is my entree into negotiation teaching and some work I do is basically fairly similar. I go, well, you've got to negotiate with your team about the allocation of resourcing or workload, or you negotiate at some level with your children when they're little about eating their vegetables. We negotiate everything. So once you start looking at, I guess, not only just the professional skill set of a litigation, but the fact that it's so sort of endemic to the human condition, how we influence, how we negotiate. And once you start having those conversations, you can see I see people's interest pick up a bit because you're not sort of telling them how you do that. You're looking at the broader skill set of negotiation.
Well, what I find really fascinating is particularly when I have junior lawyers in a room and I talk always about, you know, what's your experience of negotiation to date? And a number of them will say to me, well, I really haven't done any negotiations. And I challenge that because I say, well, have you got no friends? Have you got no family? You've never had to buy or sell anything. And I think there is this perception that negotiations are they have to be this big, complex transaction for it to be a negotiation. And this is the beauty of it, is actually bringing it back to, no, they're all negotiations. Whether you're negotiating with your flatmates about who's taking the rubbish out, or you're negotiating a multi-billion-dollar takeover, the concepts sitting there are all exactly the same. I think there's, once again, this problem of the perception of what negotiation is. So, you know, if you ask a lot of people about negotiation, a lot of people say, I hate having to negotiate, because they see it in the way that it's portrayed by Hollywood. It's this really hostile, aggressive kind of you win, I lose, Jerry Maguire kind of thing. And I know that reference is going to be way out of date for some of your listeners.
The art of the deal, for example, in modern parlance.
Oh, well, yeah, I'm not even going to go there. I know, but it's seen as this thing to avoid because it's seen as a very conflict-driven thing. Whereas, and this is what was the beautiful thing about getting to Yes, was it was And I like the fact that, while it's often called interest-based negotiation, that Getting TS brought in, one of the other names for it is collaborative negotiation. And that's what I like, because it's saying that negotiation really is just a form of problem solving, but it's problem solving between two parties who have opposing interests that need to be balanced. And I just think if we all looked at negotiation as problem solving, working together to solve something rather than this big battle to get more than the other or to get more than our fair share, people would be much more open to negotiating.
Yeah, and it wouldn't be cast as this sort of adversarial play field that is for some, because it's not. It's actually part of the human condition. As I said, we all do it in various aspects of our life. Talk us through, Nicole, the fundamentals of the structure you teach. I know it's sorry to put you on the spot here in a 40-minute podcast, but give us some highlights, if that's all right, of the structure.
The starting point for what I do is recognising that there are different forms of negotiation. So you've got that sort of adversarial hard bargaining, or what we call distributive negotiation, and then you've got the more interest-based collaborative negotiation. When we look at the interest-based or collaborative negotiation, what's at the heart of that is the 7 elements. So it says there are 7 things that are present in every negotiation, and they are all levers that you can use within the negotiation to be as effective as possible. So you've got the relationship between the parties. Is the relationship conducive to negotiating, or do you need to do some work to actually bring the relationship with the parties to a slightly better starting point? And that's where a lot of this psychology comes in as well. You've got the communication. Are the parties actually listening to each other effectively? One of the biggest problems is we come into things with our mind made up and we don't listen to the other side. Then we've got interests, which we've talked a little bit about already, which is really getting to the motivators of the parties rather than what they want. What does this thing that they're asking for give them? So it might be I'm negotiating my salary, and what I want is a salary of $200,000, but that's not my interest. My interest might be I need to cover my mortgage. I need to feel like I'm being fairly paid relative to market. I need to have something that feels prestigious when I go home and tell my family what I earn. There's a whole lot of underpinning things. So it's when we get down to those that we've got some flexibility. We've got options, which is thinking about what are all the possibilities of what we could agree to. And, one of the big problems there is that the minute parties get to something that they can both live with, they stop negotiating. But often they might stop at a suboptimal outcome. If they kept going, they might be able to actually create a better deal. You've got standards, which is how do you assess the various options that you're putting on the table. And so we've already talked about the fact that litigation is all about standards. And particularly about the interpretation of those standards. It's often that the lawyers agree on what the standard is. It's this contract or it's this legislation, but I say it means something completely different to you.
Yeah.
And then the last 2 elements, we've got alternatives, which is a really fascinating one because it says you need to consider what's going to happen if you don't get to an agreement with this person. And it becomes a really important factor in working out when to walk away from a deal, because if my alternatives, if without negotiating with this person, the only things that I can achieve by myself and without their cooperation are really poor, then a poor outcome in the negotiation might still be a good outcome if it's better than that alternative. Having said that, if I've got a great alternative available to me, then I can negotiate really hard because I don't have to accept a deal that doesn't at least come up to the standard of this alternative. And you would know as a mediator that one of the things that mediators often do is helping people assess what does this look like if it goes to trial? What are the costs of going to trial? What's the prospects of success? What does it look like if you win? What does it look like if you lose? That is exactly what we're doing, is assessing the alternative.
Yeah, that's right. What's the emotional cost? It's often a big thing. What's the emotional cost of going? The finality aspect of a dispute, it really looms large in people's minds. That's a big factor as well.
I often say, what would it be like if you could go to bed tonight knowing this was done? And just to round it out, the last of the elements is commitment, which is what do we actually agree to? And, that's about getting clarity around what that agreement is so you don't end up in a dispute down the track because I thought it meant this and you thought it meant that. But it's also about using commitments throughout the negotiation process around, one of the interesting things is I talk about you've got negotiation process, how are you negotiating? And you've got negotiating content, which is what are we negotiating about? And most people are very good at the content and working around the content and being prepared on the content, but they don't necessarily plan the process. And so planning the process, but also getting agreement on process decisions throughout the negotiation is a really good way of taking a situation where you go, we agree on nothing, to suddenly change the dynamics because, hey, we've agreed on all of these things about how we're going to negotiate. So it's clear we can agree on some things.
Yeah,
so
agreed.
once again, at a subconscious and psychological level, that can be really, really powerful.
And it can create momentum, can't it, that gets you more productive around negotiating the content. Well, thank you for laying them out. I know that a very broad compass, but they underpin your teaching, and certainly people, if they want to look at your work, can go to your website and look at the courses you run, and I would really encourage people to do that. One of the things that just jumped out at me, and I think it came down to the idea around listening and understanding is, so I've been an insurance lawyer, acting for insurers in the main. I did some plaintiff work as well. But when I was younger, as a lawyer going to a mediation or a conference, I guess I was really concerned about what I had to say. What was my client's position, what I had to say. I was maybe up against a barrister. I wanted to make sure that I sounded coherent and intelligent and knew the case and knew the facts and the law. But as I got older, my mindset shifted a bit. And I very much thought, as well as what I have to say, I certainly have to understand that. It's what do I have to learn? Because I felt that if I approached a negotiation as a process of discovery, understanding some of the nuance of that case or the drivers behind it, I was actually far better able to give my client advice on the ongoing risk because I wasn't just fixated on what I had to say. It's a subtle mindset shift, but I found it really important for me and made me a far better negotiator, far more effective, and being unafraid to question things. I don't really understand that point. Can you help me with that? Which might sound as though, well, why are you asking me that? But it really helped me have that level of engagement. Does that hit one of your points that you're referring to?
Oh, absolutely nails it. And it doesn't necessarily fit within any of the 7 elements, but I always say to be an amazing negotiator, you need 3 things. The first is a mindset of curiosity.
Yeah.
And absolutely, that's what you're talking about. What is it that I don't know about this situation that may change my perspective? What do I need to understand? What do I need to understand about them to help understand what my levers are to get them to change their perspective? So that curiosity is absolutely critical. The next thing you've got to be doing is asking great questions. So you really need to be able to formulate the right kind of questions that encourage people to share information. And there are some techniques that you can use that sort of, people will give you information they never thought they'd give you because you've asked questions in the right way. So that's really important. And then, of course, if you've asked great questions, the final thing you need to do is to listen really well. And listening you'd think was really easy, but it's actually such a difficult skill to do really well, to shut down that internal voice that's critiquing what they're saying as they're saying it, to be able to fully engage in listening and then withhold the critiquing until a bit down the road. If you can do that, it makes you such a powerful negotiator.
Yeah, and I find, for example, this forum quite difficult at times because of some delay on the online platform, whether you'll finish the point or whether I should jump in. So it's really interesting. But there's this guy his name's David Brooks. He's an author. He said something really astute that I thought, if someone's saying something, imagine it's going down from here to the shoulder to your wrist. And what happens is, and I've been guilty of this, they're saying something and about here, say halfway through, we're automatically engineering in our mind what our response is going to be or what I should say that sounds intelligent or responsive, as opposed to letting it go all that way and stopping and then responding. And I thought, I like that analogy. I've used that a bit because I'm a lawyer, of course, and I like the sound of my own voice. So I very much often stop about here and want to say something. It's a great skill, isn't it? Just to use silence, to make sure there's an effective pause and then be responsive.
It's super interesting. And the fact is I'm a natural interrupter. So when I'm chatting with my friends and everything, I interrupt all the time and I try to stop, but it's just inbuilt in me. But when I'm mediating and I'm switched on and I'm really conscious about how I'm communicating, I will just sit there and let it flow and I won't interrupt to the same degree that I normally would. It becomes really powerful. But there's another reason why that's powerful, and that's because if we are not interrupting, we're giving people the airtime, we are then at the appropriate time reflecting back what we've heard so that we've demonstrated that we actually have heard and understood them. That in itself is really powerful because human beings love to be listened to. When we feel like we're being genuinely listened to, our brains will send signals to release oxytocin. Now, that's a happy hormone. So we can actually make people feel really good, and particularly where you're dealing with angry people, if you can make them feel heard, you're just naturally disposing of some of that anger that they've got. Unless their anger is intentional, and this is what I tend to find, particularly if I get barristers in mediations, and I find often it's inverse to the strength of their legal arguments will be the strength of their anger or hostility, and that's an intentional one. So it doesn't matter how much I listen to them, it's not going to dispense the anger in that situation.
And that's maybe to derail the process or derail you and distract. So I've seen that as well, Nicole. So it brings to the point that really an important skill that mediators bring is just presence, huh? The absolute critical importance of presence in a room when you're in a conflict.
Yeah, and the work that we do in summarising and paraphrasing is critical. And that's partly for the fact that the parties now feel heard. But it's also about really we've got the opportunity to highlight where the parties do have agreement. Sometimes they walk into that room thinking that there's nothing that's agreed and that there's no alignment between interests. But if we can summarise those sort of two separate positions and really specifically, explicitly highlight where there is alignment and when there is agreement, that of itself is really powerful. And often, as I said, it's things that people just aren't necessarily looking for or thinking about, because we all, as humans, and I know when I'm in a dispute, I do the same thing, even though I'm a mediator, we get so hung up and, blinkered around our own position that we miss so much of this stuff.
Absolutely. So we're running out of time, sadly, Nicole. That was a great conversation. Where to in terms of your work? And where can people find you in terms of your business and your online presence?
Yeah, so I guess for me, in terms of the work, my shift over the last few years has been much more into the commercial mediation. I'm still doing a lot of training, but less and less over time. People find me. I don't chase people to run out and sell training courses. But yeah, definitely working in the commercial disputes area. And people can find me, the easiest place is either via my website, which is nicoledavidsonnegotiation.com.au, or you can find me on LinkedIn. And a little quiet over the last few months, but generally quite active on LinkedIn. And so hopefully you'll be seeing more of me back on that platform again soon.
Which I'm looking forward to. I've certainly linked with you for that reason. I really like looking at other voices in the market, and I thought it was interesting. You've got a unique perspective with your training background as well in negotiation and your commercial mediation. So thank you for taking the time and for your sharing your expertise. I look forward to staying in touch, and I look forward to seeing more of your thoughts and your work.
It's been an absolute pleasure, Damien, and I look forward to staying in touch too.
Thank you. All the best.